Good morning, good afternoon, good evening, guys, wherever you are. I would like to introduce myself. I'm Heather Wardrobe, Alumni Engagement Officer here at Bob Corninger University. And today I am joined with David Christie, Academic Strategic Lead in Construction Law and Arbitration. We're going to go do a bit of an overview over our last coffee morning, which was on concurrent delay, part 2. So David, do you want to give us a quick brief of what that morning was about?
Yes, well, I mean, we had the first coffee morning was discussing delay issues, and so much came out of that that it overran the time available. So we thought it'd be good to have another go, and at the same time wanted to cover something slightly different. So in the discussion, what I was trying to do this time was to help the group break down some of the concepts to do with delay analysis and the law around delay. I think in all these issues, there was a slide from, or there was a quote which I noted when Lucy Garrett QC gave a webinar at the start or a few months ago, which I hopefully will pop up on the slide, the screen, where she talked about in terms of proving delays. She said it's not difficult for a lawyer, but it's just complicated. I noted that down while she was speaking. I hope that's not an unfair paraphrasing of what she said, but certainly it's the way that I've always felt it as a practicing lawyer. For a lawyer, a lot of delay stuff isn't difficult, but it is complicated, and I think unpicking that is quite a useful way to go. So when we have a group like we had at the Decafe Debrief of both people with some construction law background, but also construction practice, and especially experience in delay issues, both as a client and as somebody analysing the delay and somebody who's also trying to work out and manage the consequences of delay, it's quite important to try and break those issues down. So because there are a lot of concepts that are bandied about and a lot of definitions and a lot of technical language, and I think it's quite useful to break it down. So what we did was hear from the group, and I tried to start making that into some sort of mind map. Now, for a lawyer, mind mapping is a sort of ideas-based thing, which I don't think necessarily fits in with the conventional view of most lawyers, but I'm sure for many of the people attending the event, it is something that's reasonably commonplace, but perhaps not been done for delay analysis. So I thought we would take what people said and put that into a mind map. I've subsequently done a little bit of work here to try and organize it a little bit, but these were all ideas and concepts that people brought up in the coffee morning. Now, being a lawyer, I've put the contract at the center of things because I think it's really the starting point from a lawyer's eye view of how you analyze delay issues. A lot of the discussion we focused on the other day in the coffee chat was around things like pacing and reorganizing the works. And for a lawyer, that would come under the heading of ideas of mitigation, how you mitigate delay and the duty to mitigate a delay. And from a legal point of view, the big balancing act is between issues of mitigation and acceleration. And when taking steps to lessen the impact of a delay becomes taking positive steps to speed up the works. And those are treated in law very differently. That's perhaps something that we can look at later. I don't necessarily want to go into the law around it at the moment because that wasn't, that is really just to highlight it as something to think about, is that there is a balance to be struck between mitigation and acceleration. And then in terms of the other ideas that came around it, it may be partly to do with the way the conversation developed. They did tend to be issues around how you deal with delay, then in the legal framework sits between mitigation and acceleration. And there are various things that are done to mitigate. So you can reorganize the works, you can pace the works where you slow down some elements in response to the delay. Much of it depends about the extent to which the contractor is reasonable. Are they taking a constructive view of things, or are they looking to make a claim? And so I'm using my hands. It's maybe not that helpful in an audio medium, but a lot of the things around here are all quite linked in this mitigation acceleration sort of nexus, and how you deal with the delays. And obviously that was quite interesting from a practical level. What we've looked at other times in the first chat was about issues around concurrency and the definition of concurrency. And I think in law that's relatively narrow now, and I think it may not in legal terms happen all that much. But what is important to think about is causation, and what is the cause of the delay, and how that, and importantly, how that is demonstrated. And that sits in a slightly different area from the issues about what you do about the delay. So in grouping the ideas discovered in the good word, and discussed in the chat, they sort of come in different sides of the equation. And then I looked at some of the other ideas we covered, which relate to the consequences of delay. Probably the main one is the obligation to pay liquidated damages, or if you're an employer, to receive liquidated damages, the right to receive liquidated damages if there's a delay. But also the costs for the contractor of being prolonged in their work on site and spending more time doing the work than they thought. And then we did come up with some ideas around that to do with losses and loss and expense. Head office overheads are mentioned as well, and those sort of concepts. So I don't really want to go into the detail of what each of these things means just now, but I think it was quite important at taking a step back to try and think about how these different ideas, which are all related to delay, fit together. And this is a very rough and ready diagram made up at the time of the coffee chat and then just following after, to try and capture what came up in the chat, and hopefully acts as a aid memoir to those who attended it, and a spur to further thinking for others. Also in the chat, I'd started work beforehand. Hopefully this won't blow it out. Nope. On trying to organise delay issues slightly more systematically. And I thought if you take delay, then you can break it down, in my view at least, into three big headings of legal issues, factual issues, and then something around persuasive cultural management issues about how you deal with the delay and how you explain the delay. And I think that is a blend of both the legal and the factual, and probably some other factors too. And so in terms of looking at the legal, if we think about what we covered in the first session, which is covered in the other Decafe Debrief, much of that comes around the definitions, both in the case law and in the contracts, as it says there, the contract and in the common law. And also it breaks down to issues of definitions then, and also of proof. And once you get into issues of proof, you're then looking also at how the delay is demonstrated factually, and that requires things of evidence. So you see there is these headings are not independent of each other, but do become linked. But the way in which they're linked requires slightly different emphases and focuses on things. When you're looking at how you demonstrate delay, then that's when things like the different models of delay, the different programming analyses come into play, and that also links into the idea of persuasiveness. In terms then of mitigation and acceleration, which were the big topics discussed at the coffee chat, they fit in legal terms, in terms of the definitions, and as I mentioned, there is a borderline between when mitigation becomes acceleration, but they also are things that are demonstrated within models and programming, because how long should a delay have been compared to how long was the actual delay? That's an assessment that these programs tend to demonstrate. So that was the mind mapping exercise. The other point which I thought I would cover was a little bit about causation. There's a very good paper which we will share with you in the notes, which is a lawyer's eye view of legal causation, but acknowledging some of the factual and, I see I'm getting in the sun now, the factual and some of the philosophical ideas about causation, and then how you demonstrate that and how you argue about it. In terms of a coffee chat, I think the substance of that was difficult to convey in a wide room. It's quite technical language. I thought what was most interesting in that paper was the reference to common sense, because common sense is often seen as the legal way of assessing what the delay was. And the author of that paper flags up that common sense has some sort of value judgment as well. It's not just we're going to take a rational assessment of the delay or a logical. Common sense suggests there's something slightly beyond that, which I think is an interesting idea, that there's a sort of question of is it right or is it wrong, as well as just did it happen. So the paper is worth reading for that, but it's not one that's very easy to just quickly chat about. But I think partly because these ideas, when you first read something, common sense doesn't have any difference from logic in it. But if you think about it, it clearly does have. There's something that somebody who uses the word common sense means, which is different from what somebody who uses the word logic means. And so when you're thinking about how you demonstrate something, think about how you persuade the person who's thinking in terms of the language that is being used. Are you providing a common sense assessment? If so, how are you demonstrating that common sense assessment compared to are you demonstrating a logical assessment, which is it's a slightly different thought exercise.
Mm-hmm.
So those were really the points that were covered. It was good to have that chat, and I think it's good to sort of bring out some of those different ideas and different ways of looking at delay.
Well, a couple of other points I picked up from the coffee morning. Now, for those who don't know me, I have no actual knowledge in the construction law industry. But some of the keywords I kept picking up on was ripple effect. Now, I'm not really sure what that is, but can you explain a little bit what ripple effect is?
I think I took it to be where there is one event can cause a delay, and that then means that other events, which might not have otherwise caused a delay, do cause a delay. So
Okay.
if you have a building and there is a delay to putting in the windows, then that means that the building is not necessarily wind and watertight. Just taking a very sort of broad brush example, there are obviously things you can do, but if you're late putting the windows in, it means you can't paint. So the painting is delayed because the windows were delayed. And because the painting is delayed, then you can't do something else that you would normally do after you've painted, or if you've plastered it, just taking a sort of standard house thing. You can't paint until after you plaster, and you can't plaster until after the windows are in. So a delay to the windows arriving also puts out the plastering, and also puts out the painter. And if you don't necessarily want to have all the paint to paint a house sitting around on your site because it's taking up space and it's difficult. So then either you have to not buy the paint when you plan to because you don't want to have it on site, or it costs you money, and cash flow is always tight in construction projects. So you don't necessarily want to spend the money on the paint until you have to spend the money on the paint. Mm-hmm. And then you find there is no paint. And there would have been paint if the windows had been in because you'd have bought the paint earlier.
Okay, so it is actually, it's very kind of self-explanatory. Like you drop a pebble in the water, ripples outwards. So there's always these other issues that occur.
And then there are questions of who should have, should the contractor have made sure that they had the paint, or did they not have to make sure they had the paint? Because there's a question of what should the contractor have been doing? Should they have waited to get the paint, or should they have bought it when they planned to buy the paint? The response to the delay is and that's why these issues become complicated. The questions are not difficult to ask, but they're complicated to answer.
Okay, and so another topic that kept coming up was what happens if termination happens. So I think this was near the end of the discussion of the coffee morning. But they were talking about what happens if termination happens throughout the project, or because of a fees happened which caused termination. So what does happen if a termination of the contract happens?
Again, that depends on how the contract is set up in terms of, and I think from what I recall of the discussion, it depends on who is responsible for the termination in terms of if you think of it as a third-party termination. So there's a one works package. So again, if you take the example of the windows, mm-hmm. If the contract for the provision of the windows is terminated, then what happens to the painter? Because the painter won't be able to paint when they were supposed to be coming in to paint. And if the painter is late in painting because the windows were late, then should the painter be taking responsibility for that? And certainly on that sort of relatively simple analysis, again, it depends very much on what the contract say. You would say, well, it's not the painter's fault that the windows weren't in. Usually, I mean, who knows how these things work out? But if you have a separate painter from a separate windows supplier, lateness of the windows is nothing to do with the painter. So the painter isn't obliged to finish when they should have been originally contracted to finish. The question will be, does the contract allow for the painter to be given more time, and are they given enough time? And that would then be dealt with by the painter and employer contract. Or if there isn't, then that is likely to be, I think, something where what's called the prevention principle would kick in, which would mean that the obligation of the painter to complete by the time they were supposed to complete flies off, and all they're supposed to do is complete within a reasonable time, which would depend on the circumstances. The other reason why termination has become a hot topic in delay is because there's been case law from the English Court of Appeal in a case called Triple Point, which looks at whether liquidated damages can continue to be claimed after termination. But that is a controversial case, which I would leave for another day.
Okay. And would you like to end with any final thoughts on the coffee morning? Any final kind of feelings you've had about it?
Just, I hope it was a useful exercise. I certainly enjoyed both of them. I think, notwithstanding all of the technical stuff, just getting people into a virtual room together is a good thing. It was great to see so many from around the world. I think if there's any feedback or any questions coming out of this, it would be good to hear them. We've got, following up from the chat, we have now got somebody talking about some of the detailed delay analysis webinar, which happens to be tonight when we're recording this, but will have happened by the time this goes out, which is a great example of being able to draw on the pool of the alumni to expand, both help the alumni and help each other to understand issues more. And we wouldn't necessarily have had that link without we had the link, but we wouldn't have necessarily had the webinar on it.
Yeah.
So that is a good way to show how we can use it to feed this and grow an alumni community. So, I mean, that's very sort of slightly pious outcome. It was useful to understand. I think I probably hadn't fully grasped how important all of the issues around mitigation and acceleration are in practice, given that was the real thrust of what was coming out of the discussion. And that's an interesting area to come up with later. In terms of what I've just said about the prevention principle, that's been the focus of my research the last year or so. So I'm trying to pull something together on that. And that will be shared in due course, and perhaps we can do another webinar then.
Perfect. Well, thank you very much for your time this morning.
Thank you, Heather, for organising.
Oh, not a problem. And thank you for doing the coffee mornings as well. They're very well appreciated, and I really enjoy them. I've joked about this, but I think one day I will actually be able to do this course and be able to have a great understanding of what it's about. But thank you all for tuning in today, and I hope you still have a wonderful day. Thank you. Goodbye.
Bye-bye.